Hi everyone, and welcome to Last Week Tonight, where we answer your questions and we talk about your comments. It's all about you, the viewer, on this episode. So let's get into it. Let's answer some of these most recent pressing comments. Here's one from just 4 hours ago from William Keene, and he says, please do verdicts for car accidents only. Recent with surgery, please. Cover more of these cases. Thanks for all your support and guidance. Yeah, absolutely. I'll do another video where we talk about car accidents with surgery and the verdicts that we see. We could actually do that probably nationwide, so it's not just confined to New York. Recently, I did a video, probably hasn't come out yet, but it was all verdicts, personal injury, but it was in New York and it was organized by the most recent. So we did verdicts as recent as just a few weeks ago, going back to earlier this year. I think we made it down to May of 2024, and we covered about 10 or so verdicts. And they were all different, some into the millions, some for smaller amounts, and some defense verdicts where you get just nothing. Here's a question from Life is Good, or Life's Good. Question, here in Manhattan, can you tell me the normal time to wait after summary judgment to get a trial date? Is there a maximum wait time? So usually in Manhattan, I would say from the time that you file a note of issue certifying the case is trial ready, from that time, usually you'll wait about a year, maybe a little bit more because of the backlogs with COVID and things like that. I don't believe there's any time from the summary judgment, because summary judgment is like a separate vehicle, where what that is when one of the parties moves and files a motion arguing that there's no issue of fact to be decided by a jury, therefore we should just get a judgment in a summary fashion, automatic judgment, because there's no issue or question for the jury to even decide. So the defendants do that, and the plaintiff sometimes does that too, like in a rear end case. So, but that's a separate vehicle. So it wouldn't be from the time of the summary judgment, it would be from the time that you filed the note of issue. So look at the note of issue date. And then Alberto says, all those appointments 3 times a week, therapy, it takes time from your daily life. It's not easy, and it's hard to get hired if you're in pain and asking permission to go to a doctor. Yeah, that's true. That's absolutely true. It is, because if you have a serious injury, then you have to get treatment. And if you're always going to treatment and medical care, then it's hard to have a job, right? Because you're never at the job. So that's the whole idea. That's why some of these verdicts are very high. You see like $1 million results, because it's a life-changing forever injury and it really disrupts your life. If it was just a little thing, like a little boo-boo, then it wouldn't be so big. It would be like a $5,000 settlement. And he also asks, hi Arkady, my question is how they calculate lost wages. If you were not working at the time of the accident and now, because of the injury, you cannot work because you have to attend therapy and doctor's appointments, and they are recommending a cervical fusion surgery and a shoulder and one knee, it's not easy with pain to attend. Yeah, so I mean, if you weren't working at the time, that's okay, as long as you had some kind of employment, like say in the 5 years before the incident, so you could show, well, I was working, maybe I wasn't working at the actual time, like that day or that week or even that month for whatever reason. I was taking a break, I was in between jobs, but as long as you can show some kind of employment history that you did work, let's say 5 years before the incident, and then you could argue, well, I was planning to go back to work in my profession, whatever it is, and then you should be able to recover lost wages. And here's another question from Around the Way. Tay, he or she asks, I'm still waiting on a video on ligament repair. Yeah, so I could do that as well. Ligament repair, I'd have to know a little bit more detail, like what specific ligament, what, because I don't think that's a term I could search, or I could try, but it might not show anything. So you'd have to be more specific, like for example, what ligament and what type of surgery, then I could find all the cases for that specific injury. So if you could reply to that comment, just let me know what type of ligament and what type of surgery. I could try to find that and see if there are cases on that. Matthew Allen says, don't forget to tell them that you don't have any control over how much you get or the attorney. It's up to the other side 100%. Well, no, I mean, I disagree with that. Like the whole idea is it's up to the case, right? If the case is strong and you see that you have liability, like it's good liability, and you have serious damages, I think you can tell them how much the case is worth. That's my whole point, right? You tell them, hey, the case is worth $1 million, pay me the $1 million, you have 30 days. If you don't, that's fine, but it's going to be, after the 30 days are up, it's going to be $2 million. And then if you don't pay that, I'm going to go to trial, and at trial, maybe I'll ask for $5 million. You can call the shots. You don't have to bow and, be afraid of the insurance company, the other side, or the defense lawyers. You can totally call the shots, and as long as the case has merit, as long as you believe in your case and you prepare it the right way, you can control how much it's worth. And we've shown that. Like we just had a case where another lawyer had like 180,000, and he was telling the client, that's a great number, that's a lot of money, you should take it. And then the client came over to us and we reviewed the case and we built it up, and instead of telling him he should take 190, we actually built the case into a settlement for 2.2 million. And I actually wanted to get more than that. It's just the client at that point said, no, I have to take it. His wife and him decided to take it, but I thought the case could even go for 5. So it's all about your mindset and your belief, and whether you can prep it to be a bigger case. So it definitely is in your control. I recently had jaw surgery and it lasted 9 hours. I woke up with a severe ulnar injury due to the positioning during the surgery. I am still in treatment, but prognosis is guarded if it will heal. Thanks for the video trying to decide how to proceed and when to see an attorney, now or when I know my injury is permanent. Yeah, you might want to see somebody now just to get an opinion as to whether there was a departure. You get the medical records, you show it to an attorney, and if it's a medical malpractice attorney, they should be able to tell you. So you could always wait, since it sounds like it's pretty serious already. Here's a question from Chris Colt. What has 2 knee surgeries received, 2 on the same knee? Yeah, so a lot of that will depend on the type of surgery. So if you needed, let's say, an arthroscopic surgery and then that didn't help, so you needed another arthroscopic, maybe that could be worth a few $100,000. But if you needed like an arthroscopic, but then they saw that wouldn't help and they needed to do a more invasive surgery like an ACL repair or even a total knee replacement, that could even be worth into the millions, right? So it just depends on the type of surgery and the overall impact that it had on your life. And here's a question from Vasto Lord. After filing a motion to compel for discovery, the motion was granted in the plaintiff's favor. The court stated that the motion is granted to the extent that the defendant shall fully comply with the portion of the compliance order. Failure to comply as stated above may result in sanctions upon further motion by plaintiff. And they're asking that they're saying the defendants did respond before the court's 20-day deadline, but they objected to all our discovery demanded. After or when a second motion is filed by the plaintiffs, I understand that the defense will have to explain their objection on the plaintiff's demand to the judge. Do you think the court will sanction the defense, or the court may order them to comply again, even though the court already told them in the first motion? Yeah, so I guess it depends on, what that order said, because it sounds like, and what the motion was about, because it sounds like if they just never responded to your discovery demand at all, and you filed a motion to have them respond, and now they responded, but their response is just saying objection, well, that's not really a response, right? Like, you know how to spell objection, I know how to spell objection. I could write objection 50 times. That's not a meaningful response. What you want is a meaningful response, a substantive response that actually responds to the discovery that you need to prove your case, especially as a plaintiff, right? Because you have the burden of proof. If you don't prove your case, you get 0. That's your burden, that's your responsibility. So it sounds like just giving you objections isn't really a meaningful response. So the court should either compel them to give you that response or sanction them somehow, or, so you shouldn't have to keep making motions over and over. But it's hard for me to say exactly because I'd have to read the motion papers and also know the prior history of what happened, but it sounds like they probably should compel them to give you a meaningful response, or possibly preclude them or do some kind of a sanction. I was in a car collision with an NYPD car, and I had a cortisone shot in my right knee, arthroscopic knee surgery, epidural in the lower back, lumbar medial branch block, lumbar discectomy, and endoscopic facet rhizotomy. The cops admitted fault. I have a lawyer. I was just wondering around, what do you think it's worth? And I still might need back surgery. Yeah, I mean, that could be a big case. The good thing with the city is they don't have any limit, like for example, 100,000 or even $1 million. It's just the budget of the city, which can be into the many, many millions. There's no limit, there's no ceiling. And with those injuries, if you had arthroscopic knee surgery, epidurals, discectomies, and then you need another back surgery, it could definitely be a 7-figure case, meaning over $1 million. Depending on a few of the factors like how it impacted your life, whether you're able to tell your story of impact, like how it impacted your relationship with the people in your life that you care about, like your family and friends or coworkers and your, basically your world, and how it impacted your activities, the things you love to do and the people you love to spend time with, and how it changed your life, like almost showing what your life was like before and what your life is like now because of this crash. And the fact that liability is good makes it even better. So it becomes like a damages only case. It could be a really big case. Interesting enough says, I read the defendant's official court answer to our complaint, and they basically listed 20 reasons denying any fault. It looks like they just shotgunned a template, and most of the reasons were obviously wrong and didn't apply to my case. Like one of the reasons was due to the statute of limitations, but we filed suit a year before the 2-year statute of limitations. Yeah, I mean, that's typical. They usually just throw in everything in there, and that's pretty typical. So he's just saying, is this common practice? Yeah, I would say it is. Sometimes they throw in things that don't apply, so you just have to kind of, ignore that. And he also asks, will the judge read this answer and see that they are obviously lying and wrong? No, the judge doesn't really read the answers so much. It's more like the answer is think of it not as an answer, but as an appearance. So you filed a lawsuit and that's your complaint, and then they've now appeared in the case. Now that they're in the case, the first meeting with the judge will be the preliminary conference where they schedule depositions, exchange of discovery, and then the judge will oversee the case if it goes to trial, and of course rule on motions and things like that. But they don't really get into the answer. Unless there's something like that you don't like in the answer that you think should be removed, then you can file a motion, or your lawyer can file a motion to strike that affirmative defense. Or sometimes if we as a plaintiff put in something like gross negligence or punitive damages, the defendant will make a motion to strike that. They'll say, oh, that shouldn't be in the complaint. You could do that, but you have to speak to your lawyer to see if it's even worth it. Here's a question from Daniel. He says, hi Arkady, great video as usual. You previously mentioned that injury victims should report everything to their doctor. Just wondering, how would a patient ensure that the doctor is doing a thorough documentation, including all my medical concerns in proper context? What happens if in court we find out that there's a discrepancy or a different viewpoint between what I told the doctor and what the doctor captured in his notes? Yeah, so I guess the way to fix that is you could periodically request, or the paralegal in the law firm could periodically request the medical records, and you could take a look at them once every 90 days or something like that, once every 120 days, every few months, and just look through them and make sure it's accurate. It does happen sometimes that, the doctor will write something that the patient says, I didn't really say that. It doesn't necessarily usually hurt you if you could fix it. I mean, people expect some mistakes to be in medical records, but yeah, if you're just want to be extra careful, you could request periodic review of the records. Okay, here's a question from Lost in Awareness. Would it be difficult to pursue a product liability case? The airbag did not deploy almost 3 years later. The car even had a recall for non-deployment. So yeah, it could be difficult if it's 3 years later, because you'd probably need the car to show that the airbag didn't deploy, and an investigation, examining the airbag to show that that's what happened, as well as the injury. What's the injury from the airbag not deploying, right? So you can't just have the airbag didn't deploy, I'm going to sue, because even though it's a mistake, you have to have an injury. And if there's a real serious injury, then you would probably bring the case earlier. Why wait 3 years? So it is hard. I mean, in some places, the statute of limitations is only 2 years or 3 years. So if the statute expired, then you can't bring a case. But if the statute's still active, you could speak to an attorney about it and see what they say. But it isn't easy that long after. Okay, I hope this was helpful. Let us know what questions you have. We are here for you. Our goal is helping serious injury victims and families. Please like and subscribe to our channel, and all the best. And if you have a case, good luck to you. I hope you get the maximum possible result. Okay, have a great day.